Welcome to the video of everything Future First Criminal Law does in our criminal cases. I'm making this video because if you've ever wondered, well, why hire a law firm to represent me for a criminal case? This is a great video for you. You're going to see a peek under the hood of what we do in every single one of our criminal cases. You're going to see that it's likely not as easy as you probably thought. You're going to see here that we go through every single thing in a criminal case so that way you don't have to worry about it. My name is Zachary Divelbiss. I am the owner of Future First Criminal Law. I have been in many of your shoes before when it comes to a DUI. I've been in your shoes when it comes to representing yourself at a trial for a crime you didn't even know you committed. In all of my years of experience, I then went to law school. I learned the best ways to represent people in these criminal cases. I learned a ton of different things that I wish I would have known before I got in my trouble and didn't know that it was going to affect me for the rest of my life. So please, if you are even strongly considering doing this yourself, please don't. Watch this video, if anything, to learn everything that you should be doing to make sure you have the best chance possible to get your case dismissed or at least get the best results there are. Okay, the first thing that we do when we go through a criminal case is we file our initial motions. The initial motions that I have listed here go through some of the things that we are going to do. You're going to see a common theme here going through the different parts of this presentation that I have. I'm not going to tell you how to do each of these things. I'm not going to tell you the words that go into them. I'm not even going to get into when each one is appropriate, but I just want you to see that there is so much work that goes into these cases. And we do this every single day here in Arizona. We know the correct motions to file, we know the right ones to file, when to file them, and how to get them to work for you the best. We have all of our NOAs. These are notice of appearances, requests for discoveries, not guilty pleas, motion to continue, sub-counsels, motion to modify release conditions, remanding grand juries, notice of defenses. We can get the judge changed with our 10.2 motions. We can quash warrants, request interpreters, and compel motions such as evidence, witnesses, all kinds of things, again, that are very complicated. Right out of the gate here, this is what's happening day one after you hire our law firm when we start getting into your case. Then the next thing that we want, and we start collecting this information even from beginning with our consultations with you, we want to learn as much as there is to know about you when it comes to mitigation. You've likely never even heard the word mitigation. Mitigation basically means the good things about you. Why are you different than anybody else who's in your same shoes? You might think, well, I'm a good person. I haven't been in trouble. I have a job. I have a career. I have a family to worry about. I might lose all of that, my future education, because of this case. So isn't that enough? And in some situations it might be. Some situations it might not be. And it's very difficult for you to express this to the prosecutor, to the judge, in the most meaningful and impactful way possible. Because guess what? They weren't born last night. They've been through this every single day. They've heard every excuse over years and years and years. So that's why we take it all as your defense attorneys. We filter through it. We find the best things possible. We spin everything in a good way. And we tell a great story to make sure that you stand out from anyone else going through the process here. So here's the things that we get proof of. And again, this is proof. We want physical, tangible, electronic evidence that is proof. You can't just tell us and not back it up. We want to know how this is going to go in your professional background. We want to know what's going on in your education, what kind of community involvement you have. Are you able to get letters of support that come from family, friends, leaders in the community, supervisors, any achievements, awards? What kind of family support do you have? Are they going to be there in court with you? What's your employment status looking like? Have you been employed a long time? Are you jumping from job to job? Are you unemployed? What kind of volunteering are you doing? Are you a part of any practicing religion? And what does that actually look like for you? What are your future plans, goals, aspirations in your life? Whether it's with your career, your family, your education, your financial situations, whether it's where you live. There's a ton of different things that we want to go into, and we can't get this information without you. What's going on with your mental health status? What's it look like if you have good grades in school? Is there any military service that you have in your past? If there is, there are some courts that might be specially accommodating for you. Have you been in any kind of rehabs or programs that we should know about? We need to know about all these things, and this is the mitigation portion of what we handle here at the firm. The next part of the legal process that we work through here at Future First is the discovery process, okay? Discovery basically means evidence. What kind of evidence is in your case? You know, this is the evidence that comes from the police, that the prosecutors get. Is there evidence that we have, your own dash cams, different things like that? So we, again, get it pretty much directly from the prosecutors, or we get it ourselves. We can use PIs to go and find information. We go through each piece of this discovery process in order to make sure we have accurate, truthful, consistent information. Believe it or not, we find things that are wrong or improperly submitted all the time, especially when we start getting into the DRs and the police reports, especially the body cams. If the body cam doesn't match the police report, we actually go through it here at our firm. This is super important. If you're trying to hire a firm that doesn't primarily do criminal cases all day, every day, then they're not even going to go through half of these things. They're just going to get you into court, make you sign a plea deal, and they're going to be happy that they charged you thousands of dollars, and then they're going to go back to representing family law clients and divorces. They're going to go back to their personal injury cases. They're going to help people do bankruptcies. That's not a good idea. Okay, you should never have a law firm represent you that does multiple different areas of the law. Only criminal cases. Anyways, we go through more of the evidence, the photographs, any electronic evidence, motor vehicle records, 911 phone calls, field sobriety tests. Very, very strategic here when it comes to field sobriety tests, especially for all of our DUI cases. Medical records, audio recordings, dash cam footage, calibrations, whether they're accurate, blood and breath tests, forensic exams, especially if there's a professional forensic examiner, which is, again, what the police try and claim that they are all the time. Brady records, which is, disciplinary records for the police, expert exams, prior convictions, CAD reports. So a ton of information that comes here in every single case. And especially if you're thinking about this, you're like, well, my case was very simple and straightforward. I was arrested in under 20 minutes and released in under an hour. And believe it or not, you could check the box on about half these things in there. Okay, and you might not realize or recognize that we actually go through all of these things on our end to see what matches, to see what doesn't match. And again, this is what truly stands out for us, so that way we get you the best results. And again, some law firms will claim and say that they do it. We do something special, and we'll tell you about that towards the end of the video that I'm creating here for you today, that we do in order to make sure you're aware of what we go through. The next thing is what we call internally here the deep dive. This is where we get through the thick of things when it comes to case representation with every single one of our clients. Okay, first, what we do is we draft an internal legal memo. This is awesome. I don't see any law firms who do this. This is an outdated thing that I think most people think is not worth it. And every lawyer tries to just memorize what's happening in your case. Well, what we do is we actually create a memo, so a Word document that covers everything that is important and happening in your case. This makes sure that we don't miss anything. We go through and outline the charges, the facts of the case, what they claim happened, any legal issues, these possible resolutions, sentencing requirements. We put in all kinds of tips and tricks here internally so we know what the newest laws are when it comes to every single one of our cases. Then, we are lawyers who've been doing this for years and years and years. This is part of what you are hiring us for, is to identify legal problems. And again, you are a competent person, I am sure. I am sure you can read a police report. I am sure you can read a plea deal. But you don't have the years of experience and training that we have in order to, when you're reading through these different things, to identify that there is a legal problem. Again, this is why we go to law school, so we learn how to read. Law school costs hundreds of thousands of dollars, and they teach us how to read. But it's so important because that's where the money is. That's where we strike gold in your cases, is when we read through the lines, we find these legal errors. These are the most common legal constitutional problems that we see commonly in most cases. These constitutional violations are Miranda right violations, illegal search and seizures, language barriers where they don't get interpreters, warrants that are getting issued, 609 motions, Desirol, identification, severancing cases. Young blood for exculpatory evidence and jurisdiction. It's listed last year, but jurisdiction is like the ultimate forgotten and overlooked tool that we use that gets so many of our cases dismissed. If this police officer did not follow the proper jurisdiction, they send it to the prosecutor. Even the prosecutors and the judges, they don't double check. Remember, they are not on your side. They are just going to process the paperwork and they're going to process you through the system. We actually have the programs that go through and double check, and then we triple check the actual jurisdiction of where this thing happened and where the jurisdiction lines happen. And again, we get a ton of cases thrown out for this simple reason alone. Anyways, again, we obviously submit and draft, argue these different motions to just suppress some evidence because of these constitutional violations, and even motions to dismiss if it's significant enough. Okay, the next thing that we get deeper into, and I'm going to go through this one a little bit more, is deviations. Deviations is something that is based off mitigation. A deviation is essentially where the prosecutors initially come to us and say, hey, Future First, this is the plea deal I want to give your client. And we say, Mr. and Mrs. Prosecutor, guess what? We would like a deviation because we don't think this is good enough. We want the case dismissed, or we want these charges dropped, or we want this jail taken out. We go through a ton of this, and again, that's where we combine whether we're using legal mitigation as far as constitutional issues, we use your personal mitigation, such as all the good things that are in your past and in your life, and we go through this multiple times with our prosecutors. Anyways, we review, submit, file all of this with the prosecutor in a goal. Always our first goal in every single one of our criminal cases is to get your case dismissed. If we can get your case dismissed, fantastic. That, again, is usually the best result for every single one of our clients. If we can't get the case dismissed, then we look to improve the different plea offers, and we'll go through some of those things here in a minute. Again, we go through all the errors and the benefits that happen in here. And then we also will identify whether you might actually have a good shot at winning a trial. Okay, it's not very often that even our firm or many other firms would recommend that you have a trial. But the reality is it's your choice. And if the prosecutors don't approve a deviation, if they don't dismiss the case, then you might actually have a really good shot at needing a trial, which again is for us to help advise you on, so that way you make the best decision for your future. We have Loom listed here. Loom is something that is extremely beneficial that we do for our clients. I have never heard of another firm who does this for their clients, and this is amazing. We will pull up, similar to what you're watching right now, we will pull up your police report, we will pull up the body camera footage, and we will record our screen and show you and point out the things that happened that were good and some of the things that happened that were bad. From the eyes of the police officers that we get to see this, from the eyes of the body cam, and then we will go through and explain the negotiations that we did in your case. We will go through and explain any plea offers that are in your case line by line so that you are completely aware of what's going on and, of course, what your options are. Okay. What most other law firms do is they basically have you come to court, and then they sit you down, and then they put a piece of paper in front of you, and then in under 5 minutes they will explain a piece of paper that takes at least 25 minutes to explain, and then they'll say, hey man, you need to sign this right now. I'm sorry we don't have more time, but this is the way it is, and I'm sure this is a really good deal. Well, we think that is wrong, okay? Now, there's not a perfect world or situation in here, but we get every single one of our clients a video a week before your court appearance, before your final court appearance there, so you can watch this and know everything that's going on. So that way you can rewind the video and double check the things that we said. It's also very integrity driven. Myself and our attorneys here at Future First, our licenses are on the line. So if we give you bad information, we're going to make sure we don't do that because it's recorded, and that could be used against us, which we would never want to lose our jobs or careers because we said something wrong to you. So we hold ourselves at Future First to the highest standard there is by literally recording our advice and giving it to you. Again, there's no other firm here in Arizona that does this, no other criminal firm. And again, whether they're great or not, you'll never know, because if something goes wrong and you call them the next day, They're always going to say, we never told you that. But guess what? At our firm, you have a recording that goes through exactly what we went through in your case. And again, my final bullet here is that you get to decide the outcome. You get to choose what your possibilities are in your particular case when it comes to your particular charges and your particular situation. Our job here as lawyers is to educate you about what's happening through the process, and then we're going to advocate through the roof for whichever decision, whichever option you want. We're going to make sure we try and get that for you. The next thing I have here is the negotiation process. Again, we list this in a different way here because negotiations are a little bit different than deviations, than mitigation, but ultimately it's truthfully the same thing at the end of the day because we're trying to get you the results to try and get your case dismissed. So if we can enter negotiations through any stage of the case, that's exactly what we're going to do. Most of what this happens is behind the scenes. So between emails, phone calls, or in person at the court between the prosecutor and us here at Future First, we try and always send a official PDF version of it first. Again, some firms will just send a sloppy 2-sentence email. That's not good enough. You're not just another number. Again, in some situations, we can request settlement conferences where we go in person and then work out negotiations with judges even. And we do all kinds of different deviation processes here that we list out, whether it's about constitutional issues, the jurisdiction being wrong, factual disputes, what the officer said doesn't match the body cam, evidentiary problems, things that went into evidence or didn't come into evidence or wouldn't even get to trial. Any legal and affirmative defenses, such as self-defense, which is a very common one that happens. You're going to get charged, but then there's an affirmative defense. Mitigation materials that we already went over, specific resolutions that we're trying to get if the case can't get dismissed. We'll look at any custodial problems. Again, this is about whether your case can go to trial or should go to trial. And again, we look at deviations as far as the prosecutor's policies. Believe it or not, there are laws in this world and here in Arizona that even the prosecutors don't follow, and they have policies that they go through with that. We know exactly what they are because we do this every single day. The best outcomes for your cases is going to be the case getting dismissed. Dismissed with or without prejudice is going to be based on pretrial issues through negotiations, through deviations, to try and get a case dismissed. Getting a case dismissed with prejudice is the ultimate best thing that can happen. However, technically that can't happen unless the statute of limitations has passed or unless you have already had a jury trial. But it is common to get a case dismissed without prejudice. So that is still a really good thing that is ultimately what we're trying to get for every single one of our clients. Now, if you do go to trial, you could potentially win the whole trial, and what that's called is an acquittal or a not guilty, okay? This is where you have a trial in front of a judge or a jury, depending on what kind of charges you have, and they determine that you are not guilty, okay? In Arizona, there's no such true thing as finding innocence. You're automatically innocent until proven guilty or not guilty. So that is the way that this works here, and again, that might be an option in your case. We also go through what are called non-plea diversion dismissals. Again, all these things that I'm going through are very advanced techniques that we use here at our firm. Not every lawyer knows about these things, and they don't work for every single case. So understand, we know when to ask for these, we know how to ask for these, and we know ways to convince the prosecutors to give you things that other firms don't. Okay, a non-plea diversion dismissal is fantastic to get the prosecutors to sit on the case for a while, let time pass, and then ultimately dismiss the case. Sometimes you'll even do some kind of counseling program. This is super important, especially if you are not a current U.S. citizen, because there are immigration consequences that come with every single plea deal. Even if you are a U.S. citizen, this is a fantastic one because there's a way to get your case dismissed without you ever signing a plea deal. Now, the next thing I've got listed down here is the diversion dismissal. Again, very similar to the one that I was just mentioning, except in this one, you basically do sign a plea deal. That plea deal, however, gets stuffed into a file. Certain amount of time passes, you complete your counseling, and then that file gets shredded. So it's as if it completely goes away and your case gets dismissed, which is an awesome outcome in many different situations. Up here at the felony and misdemeanor compromise, this is where you pay a significant amount of money in order to try and get your case dismissed. If you've ever wondered, how do celebrities, how do all these, professional athletes get their cases dismissed? This is what it's called. It's called a misdemeanor compromise or a felony compromise, where they exchange, and I'm talking over $10,000+ of a voluntary donation. So this isn't like, I've got an extra $500. This is serious cash that is well over and above. This takes a very long time to get, and again, it's not very common, but this is what that option is, which does work for some people in some situations. I also list here what's called a free talk. This is where essentially you snitch on someone else about something. Not usually something we recommend because there's no guarantees in those situations, but that could be a way to get a case ultimately dismissed and dropped. Undesignated felonies here in the Arizona system are fantastic. It is a great tool if you get initially charged with the felony. If your case can't get dismissed, then ultimately we want to get you a undesignated felony down to a class 6, which basically means it's an offense. It's not designated a felony, it's not designated a misdemeanor until the end of whatever your punishment is. If you complete everything, then you can hire us back and apply to get it then designated as a misdemeanor. If you don't complete everything, the judge will order it be officially a felony, which is obviously not good in the sense that you'd rather have a misdemeanor over a felony. We could also plead to a lesser charge. This is very common. We try and get, many of our cases, if they can't get dismissed, we try and get a lower level charge to plead guilty to. So this commonly happens in DUI cases. If there are tons of problems with your DUI case, well, the prosecutor might not be willing to dismiss the case, but sometimes we can convince them to give you a reckless driving instead of a DUI, because reckless driving has less punishments that come with it. Still a criminal violation, still counts as them getting a conviction, but again, it's usually a better result for you. There are also some other non-mandatory lesser charges. Again, we were talking about reckless driving in here. Some things that are just, again, very advanced that we go into with every specific case of what is included, not included. This happens in assaults, disorderly conduct cases, in trespass cases, in speeding cases, trying to get defensive driving school. There's a ton of different things that we go through here. And then, of course, there's what's called just the standard conforming charge. This is where you're going to get maybe stuck with the original charge that you had, but likely you can get some kind of different punishment, or even you can get a lower level charge, but then a similar punishment to as if it was still the higher charge. So again, there's benefits, and these are some of the best outcomes for many different situations. Interviews, this part of the process here, if we can't get the case resolved with everything we went over and the best possible outcomes, we might have to start doing interviews. Interviews is the way, is on the path to having a trial. We call them interviews in the criminal world, but really it's a deposition. We're not interviewing someone for a job. We're interviewing usually the police officers to have them tell us from memory exactly what happened and to see if that matches. Again, if there are big enough problems, we might be able to try and get the case dismissed. We go through a ton of different things that I list here. Again, there's very, very, very advanced techniques here that we use. And this is definitely something that you should not be thinking about or even trying to do yourself. Ultimately, if we get no dismissal and you want no plea deal, we will eventually end up with a trial. As I mentioned here, a trial is always inevitable in a case unless it gets dismissed or unless you accept a plea deal. Eventually, you will have a trial. Okay. Again, there could also be situations where you do want to have a trial in some particular situations. Again, we go through all different kinds of things here that we go through and focus in our firms, whether we go through the police officer, the witness, the victim's testimony, their interviews, the evidence that we're looking at. We're looking at motions in limine, all different kinds of now new motions that we will file in anticipation of the trial, in order to make sure the trial goes in your favor. Ton of different things we're going to do here. Tons of different things we're going to try and suppress from your trial. In many situations it works, some situations it doesn't. There are, of course, aggravating factors, so things could get worse at a trial. We review and go through every single thing here again. Ultimately, We come here to the right side, which is the defense's case. We look at the best facts, beyond a reasonable doubt, presumption of innocence, defense's notice. We go through all the different jury selection process, voir dire, evidence gets submitted, demonstrative evidence is used. We go through all the witnesses, subpoenas. The defendant may or may not testify. We go through objections. We have to then outline jury instructions. We go through cross-examination of what the witnesses say. We outline and use our openings and closing arguments. We rule 20 to try and get cases dismissed during a trial. We try and get lesser included offenses. So literally the dozen plus things there happen just at a trial, okay? So sometimes if people are wondering, why is there extra cost for trial? Because there's literally twice the amount of work that happens at a trial than it does trying to get a case dismissed or trying to get a really good plea deal. Ultimately, there is sentencing. Sentencing is the final stage in most cases here. Okay, what this means at sentencing on the felony side is you could have and will likely be required to do what's called a pre-sentence interview. Okay, this is where they're going to ask you 100 different questions. The defense counsel, we're usually not there with this. This is with a probation officer. We basically say that there are 2 things that you should not do. Well, maybe 3. Number 1, please don't tell them that you're continuing to commit crimes or use drugs. That is not a good thing because this report will go to the judge and you will get in trouble. These probation officers will say, tell me what happened in this case. Again, we recommend you don't talk about that because they could misconstrue what you said and you might admit to something that they didn't even know before. And finally, the last thing that these people will ask, they'll say things like, how do you feel about your punishment? And again, we say, tell them that your lawyer told you not to answer that question because they can twist those words against you. Nobody's usually ever happy with some of the punishments if they're taking a plea deal. Anyways, we go through the PSR. The judge will look at, we review that. That's everything that we go through. This happens usually a day before court, which means that we are in a super rush to go through and analyze this. We go through all of our own processes as well in letting the judge know all the good things that are happening in your life. And again, other mitigation materials. We'll recommend that the judge follow our sentencing recommendation. And then ultimately, this all happens at a later time when you accept a plea deal or after a trial. In misdemeanor cases, it's much less formal, okay? The misdemeanor process pretty much all happens at the same time. There's no pre-sentence report. There's no real sentencing recommendation. There's not much mitigation that's submitted to the judges because everything that we usually do in a misdemeanor case is already written in the plea deal. The judge doesn't have any leeway, which kind of means that the prosecutor is really the strongest person in the courtroom. The prosecutor for a misdemeanor case is who we are really trying to convince to drop cases and to give you the best deal possible. It's usually not the judge. Spoiler, if you didn't know that. All this happens at the same time. Again, you can accept a plea deal and get sentenced the very same day. And again, after this is done, this is usually where we and most law firms will enter a motion to withdraw. So that way it ends our representation. And as a courtesy, if there are things that you're supposed to do afterwards, you send them to us and we will happily send them to the judge. So that way you can get credit for everything. The next thing that happens in most of these cases is we file a motion to withdraw. That is what officially takes the law firm off of the case. This is very common among all law firms because you are the one who is going to be then receiving a lot of the paperwork after the fact. As a courtesy, we will go through and send everything to the court that you might have, and we will do that again as a courtesy. But what our law firm does that is super important that other law firms don't do. What other law firms do is they shake your hand at the end of your case, they wish you the best, and they say, see you later. What we do is we go back to our office, we input into our computer system dates to contact you again in the future, whether this is 6 months, up to 2, 3, 4, 5 years into the future, because there are some extra benefits called post-relief benefits or post-conviction relief that you can take advantage of. Most lawyers don't tell you about this, and we want you to hire us back so we can get these things done for you. We've represented so many clients who, if they had only done these things, they wouldn't actually be in the trouble that they are when they needed to hire us, because Arizona's laws about repeat offenders are so harsh. So some of the things that we will go through and do this is we will try and get you a set aside. We will try and designate your felony down to a misdemeanor. We will go through and try and terminate probation early. We will go through with Arizona's new law called sealing records to try and get your whole case sealed, basically off of your record, all of your gun rights, your voting rights, all restored as if this never happened to you. We truly believe that people make 5-minute mistakes and it shouldn't define your future for the rest of your life. This is important that we do this, so we reach out to every single one of our clients. We care about where you are with your future. We hope that you have a successful career, a family, an education, and you don't end up back up here in the justice system and having us represent you again for a different crime. We believe that when we follow up with you and let you know about these advantages that you have that you should use, that it is going to set you up for success in the long term. Again, this is very important. We want to firmly believe that you have the best chance of succeeding here after our representation, so that way you don't continue getting in trouble. And that's part of why we educate you about the process, and then we advocate for you in the best way possible, and we double check anything you might be eligible for, and we will call you and ask you about it. Again, please, if some of these things come up, if you are watching this video and you've made it this far, you are likely considering or were on the fence about hiring a law firm to represent you with your case. You should now see, just through the things that I've glossed over, how much work goes into representing every single one of our clients. We want to represent you if you are within our jurisdiction and if you have the type of case that we take. It is super important as well if you are struggling financially or you want to hire us but you don't think that you can afford us, or whatever it is that you've heard somewhere else on the internet or from another law firm, please call us so we can talk to you about your specific situation. Don't let somebody else ruin it because they quote some outrageous $100,000 price because they're a billboard lawyer. Talk to us at our firm and talk to us as soon as possible. The sooner you talk to us, the more we're able to be flexible and work with you. If you wait till the day before your court appearances, things get really tough for everyone. We want to represent as many people as we can. We love helping people get a better future. I've been through the system before. I hate that people have to go through this. Jail's not the answer here in Arizona, and these convictions pretty much last forever and have unintended consequences. So if you're dealing with any of this, please reach out to us as soon as possible. Every single person here on my team is the most well-trained that there literally is when it comes to the criminal world here. We all can represent you diligently, and we all want the best for you because we believe in our mission. Thank you very much for making it this far, and again, please don't hesitate to reach out to us.